heard the other one? Right. Okay.
Yeah, we're live.
Yes. Are we live?
Yes.
Okay. Thank you all. We will reconvene, and we are now moving on to consideration of the Section 42A report and posing of questions to Matt Hill, the author. And it may also generate some discussion with the other experts that we have present as well, and also with Shelley online. Matt, is there anything you want to add before we start in the questions?
No, not me personally, but Shelley, I think you were going to talk about the commencement date issue that came up yesterday.
Kia ora noa. So I just wanted to, we were in a bit of a chain of talking about the commencement date of the MPSIB last night, and I just want to firstly reflect on the fact it was the end of a very, very long hearing, so I'm not 100% sure I was following everything that was being discussed, but I want to contribute on that date of commencement and how it carries through in terms of the definition of SNA in particular and the MPSIB. My understanding is that the MPSIB commenced on 4 August, and that is based on a calculation in accordance with the initial clause, which says it commences 28 days after notification in the Gazette. So that for me, by my calculation, is 4 August. So our plan was notified, as you know, on 31 August. So playing that through in terms of the definition of SNA, or significant natural area, there's 2 paragraphs which mean that there are different implications because of those particular dates. So for subparagraph A of SNA, any area that after the commencement date, so after 4 August, is notified or included in a district plan as an SNA. So that captures our 2 SNA areas. There's not a lot of debate or discussion about those 2 SNA areas. I think that's relatively settled. Subparagraph B of SNA, of the definition of SNA, sorry. So any area that on the commencement date is already identified in a policy statement or plan. So commencement date 4 August is already identified in a policy statement or plan. We didn't have any areas identified in this plan on the commencement date of the MPSIB because our plan hadn't been notified until the 31st. So subparagraph B does not apply. So subparagraph A captures SNAs that were in the notified plan. Subparagraph B doesn't capture any because our plan was notified later. So that's my comment. I hope that helps in terms of what we were discussing last night, but please fire any questions at me if you have any other points of clarification.
Is there any additional comments you wish to make with regard to the amendment that came into force in October last year, which was after notification of the plan, or are the parameters that we need to look at solely related to at the time of the initial document?
So as we've discussed previously, the position that I am presenting is that you apply the law and the policy as at the date, today's date effectively. So we're discussing the MPSIB and the legislation in place as at today's date. The MPSIB in particularly, I just want to note, particularly the process provided for identification of SNAs in subpart 2 of part 3, that doesn't apply to our process. So this council made a decision not to identify SNAs. There are only 2 identified in the plan, and there is no subsequent identification of SNAs proceeding in the context of this process. That was essentially parked to be completed under the NPSIB in 2023, it was a 3-year time frame, and now it's a different time frame. Now, all of this is summarised in Mr. Heal's Section 42A report, and he's got he's got an overview in his 42A at paras 43 to 51. I don't understand that Doc or anyone else opposed that summary in terms of how the NPSIB is applied or not applied in the case of mapping SNAs at present. So I do think there was a little bit of people talking past each other last night in terms of the application of the NPSIB. My submission is that you are applying the NPSIB in terms of the objective and the policies. And then in terms of clause 3.16, which is where Commissioner Bartlett focused quite a lot of her questions yesterday, which is Indigenous biodiversity outside SNAs. And I would just note, Commissioner Bartlett, today you were referring to clause 3.15, which I don't think was the correct reference. I had took your questions today to be regarding 3.16.
Yeah, I think I meant 3.16.
So my submission is you are applying the NPSIB in terms of the overall policy framework applicable to Indigenous biodiversity outside SNAs, excluding our two SNAs that are identified and aren't particularly contentious. You are also applying Part 2 of the RMA, and you're also applying the RPS. And the subsequent SNA process is to be followed by Council. At present, Council is directed to follow that within the time frame recorded in Mr. Heal's 42A. And therefore, the Amendment Act doesn't play a significant role because the Amendment Act parks the SNA process and the application of NPSIB in a way that doesn't actually apply directly to our process. There are some minor specified amendments which sit around the edges, but I think overall the general position across the board is set out in Mr. Heal's report.
So if I can just focus on one of the issues that are in the Section 42A report at paragraph 50, and you made reference to 43 to 51, and that is, what is the legal status of indicative mapping that was undertaken showing the areas of significance?
So my understanding, I actually wonder if this is an overlapping question between Mr. Hill and I, but my understanding of the indicative mapping is it reflects the RPS as opposed to the NPSIB.
So is it appropriate to use that as a base that, I guess from the implementation point of view, there's this indicative mapping that's going to sit outside of the plan, and if people are wanting to clear any Indigenous vegetation, the regime that's being promoted is that you have a look at this indicative mapping, and if you're in an area that's shown on that mapping, then you should be doing an assessment to see if you need a consent. And my question is that approach legally valid?
So just quickly on the mapping point, so a map is effectively the same as a rule in which it carries legal responsibilities. The indicative mapping, as I understand it, is an information layer which supports the process in the plan, which I will then pass to Mr. Heal in terms of how that functions as an information layer only, and not the mapping, which has the higher level of enforcement in terms of when compared with mapping of other features, for example.
So if the rule refers to those maps, that makes the map the first kind of map, i.e. at the point that a rule refers to the map, it's no longer indicative, it's functioning as part of the rule framework, yes?
That's the question. So it then comes down to what is the status of indicative maps that are referred to in rules? So are they rules with force or not?
So the maps aren't referred to in the rules. The SEVA is referred to in the rules, and SEVA is determined, whether you're a SEVA or not, is determined by an analysis against the RPS Appendix 3 criteria. And the maps are the work that we have done to identify whether we think you are in a SEVA or not. So the test is whether you meet the criteria in the RPS Appendix 3 in terms of the rule. The mapping is indicative mapping that it identifies where we think those SEVAs are.
So Shelley, given that explanation, is it valid to have a rule that refers you to criteria that in an RPS to determine the status, given that the criteria are such that you need to then undertake an assessment to see if you're meet or are included in or excluded from those criteria?
So it is an approach taken elsewhere, and it is one of the more difficult types of rules that we do see in relation to Indigenous biodiversity. It's not easy to apply in the same way as 2 metres high fences, for example, but it is an approach that's clear because it's referring to a specific document, so someone can engage experts or read that document in order to try and understand how that rule operates. The information layer supports it, but the actual legal test, shall we say, or the enforceability of the rule comes through the reference to the RPS criteria.
So for the avoidance of doubt, you're saying the approach that's been promoted is legally meets the legal tests?
It is clear and understandable. I acknowledge it's not an easy rule to apply, but I would also comment that that is the approach that has been taken across other plans as well, because this is a difficult topic.
So, just so I'm clear, when I'm reading Eco R2 and it's pointing to Appendix 7 and Area A or B or Area C or D, those areas are mapped areas, and I think from the dialogue with Doc yesterday, this was kind of the key point, I think, that everything was radiating out from. So that looks to me like that the rule is relying on mapping.
That's correct, and the map is in the plan as Appendix 7.
Correct. So that means that we are not talking about an indicative layer. We are talking about mapped areas that have a function in the rule.
For Hokonui Hills, but for everywhere else, we're talking about an indicative layer that's triggered by an assessment against Appendix 3 in the RPS.
And that is the difference, and that is the crux of the doc evidence that was brought to us yesterday, and why they were focused on Eco R2 and the Hokonui Hills, and the relationship of that mapping that's functioning in the rule as it relates to the NPSIB and the RPS. Yeah. So I can accept indicative mapping as it relates to outside of that area. I guess we have to look at how that's working with the rules, but you know, that's making more sense. But once we get into the drafting of Eco R2, it does seem to be no longer indicative mapping. It's a rule function at that point.
Can I also just comment, it's not my understanding that Doc was trying to say that R2 was or wasn't meeting NPSIB. I recall Ms. Warnock acknowledging that the NPSIB has the application as summarised in Mr. Hill's report. She didn't challenge that at all in her submissions. So it is focused in on the RPS and Part 2.
And And the test of significance.
And the application of clause 3.16.
Yep. Yep.
Okay, so that I think helps us in terms of where we're heading in a number of the questions. I'm just wondering, so we're not jumping all over the place, whether it might be best to focus on the general submissions, and then we'll look at the objectives and policies, and then we'll do the questions on the rules. Notwithstanding there is a little bit of overlap, and at some point we actually need to go through the detail of what's in your updated Appendix 1. But there is one issue that comes up straight away in terms of Appendix 1, with probably, I think it's Rule Eco 1, R1, where in the right-hand column we've got the words where, number 1, and nothing follows.
Yeah,
Should there be something there?
No. So the way that rule works is it's a restricted discretionary activity where you haven't achieved Eco Rule 1A1, 1A6, and 1L. Okay, so automatically that's saying it's a restricted discretionary activity if you're not meeting those standards. So strike through the words where and then the red one.
Yeah.
But that has a flow-on effect if we're taking that approach. If you go over to Eco Rule 2 on page 14, there's a bit of a double up there because you'll see, so you would strike out the where one in that line, but in the line above that says Eco Rule 2 1A to Eco Rule 2 1, I think it was G, it should say J.
With the additions, yeah. I struggled with Rule 1 because the layout is a little bit different to elsewhere, but I'll come back to the detail.
Sure.
Because I'm not certain that everything that you're intending to be covered by the rule is actually dealt with in the right-hand column.
Okay.
So in terms of, I guess for the want of a better description, if we deal with the general matters and the definitions, which probably covers the first 50 odd pages, up to the mapping. So anything up to page 50, if the panel have questions of that, we'll deal with those before we move on to the next chunk. So have you got any questions you want to raise at the beginning, Glenys? And I guess we had a bit of difficulty in dealing with your reports in terms of there was a regime that was promoted in your Section 42A report, and we spent days going through preparing questions on it to be greeted by some supplementary evidence that said, hey, changed our mind on this. So it would have been good to have had something up front saying, I need to make you aware that there is a significant change.
And there's supplementary evidence.
Yeah. Well, so even if a memo had come with the supplementary evidence saying the supplementary evidence is attached, but for your information, we've recommended significant change. And what I've dealt with in pages X, Y, and Z in my 42A report is really superseded by what's in the supplementary report.
So an example of that would be the council approved biodiversity management
Correct.
plan.
Because I see I've still got little stickies all over your 42A report. So, Maria, is anything you want to raise in the first 50 odd pages?
I'm probably going to throw to my left, but just because of the dialogue we were having just before the break around scope, what we're looking at here with Eco R2, would you agree it's a logical example of the difference between where you start at the point of notification and how a plan can move in relation to submissions and evidence?
Yes, absolutely, because we had submissions specifically seeking a precinct general approach, and as a result of those submissions we have introduced Eco Rule 2. And obviously in the landscape chapter, specific rules relating to Hokonui Hills off the back of those submissions, and that was not what was notified.
So, if we accepted the logic that was put to us in legal submissions by federated farmers that we should be limited by the extent of the plan at time of notification, if we accept those submissions in other parts of the plan, what would be the consequence to this part of what you've proposed in your recommendations?
Broadly speaking, we certainly wouldn't have Eco Rule 2. We would still have the old Eco Rule 2, and which related to, I think, weeds and pests 2 and 3, which we've now struck out off the back of submissions. So yes, the scope is determined by the scope of submissions. And I think the other thing I would add is that concerns raised about people not being aware of change, it's quite different to a resource consent, for example, which doesn't have a further submission process. So if someone reviewed the plan, they were, say, not worried about it, further submissions came out that, for example, introduced a natural character chapter or sought a precinct, people would have had the opportunity to put in a further submission. So that's quite different. I think the other thing to bear in mind is that this is a full plan review, it's not a plan change. And so when you have a plan change, for example, say we were doing a plan change that introduced a biodiversity chapter, and someone submitted and said, we think we need a natural character chapter, you should do this as part of that plan change. That's quite different to a full plan review, because everything's up for grabs basically in a full plan review, whereas a plan change is limited to the scope of that plan change.
That's the point about submissions being on the plan.
That's correct.
And so when you've got a full district plan review, the submissions on the plan have the full scope
Of
the
whole
chapters
plan.
of the whole plan. Yeah. And actually the obligation is if you want to have influence over the final product, you would first either need to put in a submission or a further submission, and then engage and be involved in the process through appearance or tabling of evidence, and that could be lay or expert, but at a minimum you enter the process with your submission or further submission, and we give we in our decision must take into account all submissions and all further submissions received. whether people turn up to the hearing or not.
That's correct. So people don't necessarily need to present evidence at the hearing. If they've got a submission, then you can consider that, and that gives them scope to lodge an appeal once the decision comes out.
I'm looking at page 31, and at the top of the page 31 is reference to Jenny Campbell and her request to include provisions relating to ecological corridors, and it was something that was raised with Forest and Bird. So what provisions are in the plan that actually identify and provide any identification and management of ecological corridors?
So if you have a look at paragraph 138, where I'm responding to that submission, we don't specifically refer to ecological corridors, but what we do have are rules that can control things like stream setbacks. So built and streams can potentially be ecological corridors because they typically have vegetation along them, and they potentially connect areas of bush together. So there are rules that limit buildings, etc., close to streams, and the rule, the Indigenous biodiversity clearance rule, is about clearance of Indigenous biodiversity. So even if it's not identified on our indicative maps, if it is Indigenous biodiversity, then those rules apply.
And the response you gave is pretty close to the response you gave to the submission in the surface of water reports, so whether it was you or someone else. But ecological corridors are more than just along river edges. Where I live, the tuis fly from the Hokanui Hills, rest on the trees that are about halfway, I'm told, and then continue their flight path over to me. So I guess I've got an ecological corridor from that point of view in very simple terms. So they're also terrestrial. So what opportunity is there to identify and protect ecological corridors that are terrestrial, not just on rivers? So it may be an issue.
Well, I'll have a go, and Mr. Wells can follow, but I guess there's what you can control in a district plan. So it's very difficult to control the flight path of birds. What we can control is manage is their habitat, and we have done that to a degree by having rules that manage Indigenous vegetation clearance generally. That doesn't control exotic vegetation, for example, and that may be habitat for some species that fly between different areas, etc. I don't know if you want to add any. I suppose the other thing is the indicative mapping does identify significant Indigenous vegetation and Indigenous vegetation area indicatively, and some of those areas might potentially be double up as a corridor, but I'll leave Mr. Wells.
Bats might be a better example than birds.
Yeah, I think also the other thing is any ecological assessment for consent is obliged to consider ecological corridors, connectivity, fragmentation, and ecological context. So it's, for example, it's every time an ecologist would do an assessment for some new use or development, that is one of the list of considerations that always comes into play. So I think even if it's not explicitly mentioned in a plan, the fact that there's mention of significance criteria and other, ecological assessments, that definitely ensures that component will come into consideration. So that's probably what I'd add to Mr. Heal's comments. Also, within the Gore district, there's, given the scattered nature of indigenous vegetation and habitats outside of those two distinctive areas that we've talked about previously, that there are scattered patches, and I think definitely corridors come into consideration as one of the key factors when you're talking about potentially clearing areas through consent.
Suppose the other thing I'd note is that the submitter hasn't identified any corridors, so it's very hard to give them the relief they want without.
Does it link to
extending
Eco P6 too and the restorative element?
It definitely does, and I think that's a very key aspect. And as Mr. Hill just said, I suspect the reason no corridors were referred to was because they're very, very hard to come by in the Gore district. They would almost need to be re-established through restoration efforts. The standard, what we have is more what Commissioner Hover was saying, where you've got, if you like, islands of habitat, and they create connectivity across the wider landscape, but wouldn't technically be ecological corridors per se, because they're not continuous in nature.
It would also be for roosting purposes as well, because some exotics can be used for that as well. So, yeah, some of the larger birds need roosting areas.
That is a good point. Exotic vegetation can provide those same services, and I think also it feeds in with some of the MPSIB's requirements for highly, specified highly mobile fauna habitat as well. These things can come into play, and those assessments have not yet been undertaken for the district.
Would you expect to find something relating to ecological issues in the subdivision chapter of the plan?
From memory, I think there are references to, if it's not sensitive environments, it might be specific reference to SNAs or SEVAs. Sorry, I haven't got that in front of me.
Can't see them in the rules.
There was a amendment through this sub R4. 6, the site does not contain a SNA SEVA, threatened or at-risk declining species or outstanding natural landscape or feature. So
is there any is there any benefit in terms of highlighting or part of a corridor?
when you say highlighting, do you mean in the
that
clause?
list that you just gave, adding ecological corridor to it?
Possibly, but we haven't defined what an ecological corridor is, so you would need to do that to reference it in a rule. As Mr. Wells said, in looking at the impacts on that SEVA or SNA, you would also look at the function of that SNA or SEVA. If it was an ecological part of an ecological corridor, then that's something you could consider.
I wonder though if Commissioner Havell was thinking about the restorative element there.
Enhancement was the word that came to mind.
Sorry, the other thing I haven't got in front of me is the general, if we're talking about a stream corridor, then there is reference to Indigenous biodiversity values in those matters of discretion, I think. Yeah.
I was just going to add that if we are thinking about subdivision in the general rural zone, those lots are relatively large, And so they're not the sorts of subdivisions that would normally perhaps preclude a corridor from being retained or developed. I mean, if an urban subdivision could, you know, have a greater effect, but in the rural environment, I think that's probably relevant.
So 8 hectares is the minimum. Do you still consider that large?
Well, relatively large, and when you have those in conjunction with the clearance rules, I think that if there is any corridor functioning that's existing, a subdivision doesn't necessarily preclude that from being retained.
But if there's not an assessment matter or part of the subdivision, you're not going to have regard to it other than in a SEVA and EVA. That's I guess where my thinking's heading.
That's correct, yes.
Although any new use or activity requires an ecological assessment, which will require you to consider the full range of ecological values, of which SEVA and EVA are always only part of the ecological values.
But my point is, though, the subdivision chapter does not require consideration of the ecological values.
It would only be if you were clearing something as part of that subdivision that you would, yeah.
I have a question from page 21 regarding the Southern Regional Pest Management Plan, and note that you've said Eco Chapter is consistent with that, but it's only managed alongside SEVAs and EVAs. What happens in those significant areas or areas of biodiversity like the Hokanui Hills?
So in terms of weed and pest management, so at the moment, subject to what we discussed about yesterday in terms of, at the moment, the rule talks about you can, effectively it says you can clear indigenous vegetation if you're doing so in managing weeds and pests. That wasn't the intention of the rule. The intention of the rule was to enable you to remove weeds and pests, not necessarily clear indigenous vegetation to do that. What we talked about yesterday was making that a note rather than part of the rule to make that clear. And generally, though, if you're outside, if you're anywhere in the district, the regional pest RPMP controls the growing or establishment of pests. Okay, so the district plan doesn't need to address that point.
Did you give any further consideration to mob stocking, or a different word for that?
In terms of the
Terms
definition we were talking
definitions.
about yesterday.
Mm.
So I think where we came to yesterday was that the definition of indigenous vegetation clearance talks about no damage in effect, and if mob stocking results in damage, then that would be considered indigenous vegetation clearance.
But do you need to include that along with the other
Yeah, we talked about rather than mob stocking, because it's a motive,
different word?
actually having overstocking.
Overstocking, yeah.
Because
Yeah.
all the items that are listed there are physical things, not living.
No, they're mechanical.
Yeah.
Yes.
Mm.
So I'd have to, I think Andrew or Mr. Wells talked about that a bit yesterday, but I don't know if there's anything else you want to say about mob stocking.
I suppose the difficulty with that is a lot of these areas of indigenous vegetation have historically been grazed and currently are. So by default, any stock access to indigenous vegetation will damage that to some degree. So I think that could be quite a dangerous definition in the sense existing activities would need to make sure they're excluded. So the overstocking would then presumably have to mean above and beyond existing, you know what I mean? So it gets quite complicated. I'm just thinking of situations where, you know, stock grazing ongoing damages indigenous vegetation, but that's been going on for decades, so I'm not quite sure how that, it would have to be new. I guess we're talking about new activities only here. Would that be?
That's actually what I was referring to, because as I noted yesterday, there's large tracts of tussock land where people have intensively grazed with cattle and they're completely wiped out. I mean, it was to cover that.
Yes, and that's a good point, because that does cause damage, and if that's consistently overstocked, then it will displace the indigenous vegetation over time.
So we wouldn't be protecting indigenous biodiversity, would we?
Not if it was again a new activity.
I think the difference is we've indicatively mapped those areas, and if as a result of overstocking you are destroying, damaging or removing vegetation, then it would be captured by that definition as it stands at the moment. And because we have indicatively mapped those areas, if they are cleared in the future, we have at least some record. It might not be 100% accurate, but we've got an idea of where that vegetation currently exists, which is a lot better than what we've got in the operative district plan, because the operative district plan doesn't control this at all.
Would consider it's too late then, because it's gone, and you're looking at it retrospectively.
Yeah, I guess what I'm saying is you currently, under the operative district plan, if that happened, you couldn't take, there's no enforcement action, right? But because we've got this definition of indigenous vegetation clearance, and if you're doing indigenous vegetation clearance, apart from the things that are permitted, you need a resource consent, okay? And if as a result of doing any action, you are destroying, damaging or removing indigenous vegetation and it's not a permitted activity, you need a consent. At the moment, under the operative plan, you don't need a consent at all.
Who would monitor that? Is another thing. I mean,
typically these things are monitored by enforcement. You know, if someone complains about something, enforcement officer will go out and have a look and look at the plan rules and say you're complying with those plan rules or you're not. I suppose the other thing I think I mentioned in my supplementary evidence around this 5-year time frame for the 50 square metre clearance, I think there's councils are required to do efficiency and effectiveness monitoring every 5 years and a plan review every 10 years. So those are opportunities where you can look at what's happened. And so, for example, going forward, because we have that indicative mapping, in 5 years' time we can go, oh, well, we can remap in 5 years' time and say, well, have these rules been effective at achieving the protection of those areas or not? Yeah, so there's enforcement monitoring, but there's also state of the environment monitoring that the council is required to do every 5 years effectively.
there is no requirement to fence off these areas at the moment, is there? I mean, it seems when we're talking about net loss of biodiversity that allowing stock into areas significant areas of natural biodiversity, that there is going to be a net loss?
Well, potentially, but coming back to Mr. Wells' point, that has been part of the history of the district too, and the MPSIB, to a degree, talks about enabling existing activities to continue. So it's finding that balance, I suppose.
I think fencing obviously leads to enormous enhancement of Indigenous biodiversity in areas of Indigenous dominance. So that's always a given. But there's a historic use which has to be recognised by council, and then also I guess there's the issue of fencing would lead to a great gains for biodiversity, whereas as I understand it the requirement is to maintain. So to me that would move into a voluntary option for landowners, unless there was a consent on the table, and then that could form part of an effects management process.
Which we QE2 covenants, and that they, if you do something like that, that they will pay half of your fencing costs to protect those areas. Yeah, just noting that.
I suppose fencing is something that the planner could consider as part of a resource consent process, so as a condition of consent. Fencing itself is provided for as a permitted activity in the rule, where you're not at the moment, in terms of where you're not clearing more than what has historically been cleared. So there's nothing to stop landowners fencing off significant natural areas. It's just not a requirement, but it could be something that is considered as part of a resource consent process.
I anticipate that this will be something the panel will discuss at length. Now, what I'm getting from your assessment is the historical practice of grazing under Seivers and Evers is not resulting in substantial loss, but there is expected to be an incremental increase. So I would take that to be that there hasn't been overstocking in that traditional practice. The alternative is total exclusion, which is quite different than historical practice. How would you encourage the historical practice to continue without progression to overstocking?
I think that's a farm management issue, but I think if you were talking about a rules framework, then I think that would go back to existing use being of, I forget the exact terminology, Mr. Hill will know it better, but it's where the use is not any greater than, in scale or type or intensity, than the historic use. So therefore that would mean if you consistently, say, run mobs of sheep, then that would continue, but you wouldn't be moving into an intensive dairy use of that paddock if it had Indigenous vegetation. That might be, that's just one example. I'm not trying to say anything more than an example. Or if it was a large paddock where you put out, you know, a standard regime, that you wouldn't then be putting in 5 times as many stock units. That's how I would imagine that would play out in terms of a rules framework.
I'm not comfortable with the rules framework because traditional practice has produced what's out there at the moment, which has not identified wholesale degradation. Can you have a statement of best practice, or can you have a policy without rules?
It's very difficult. I mean, I guess that was the part of the discussion around a council-approved biodiversity management plan, which is very difficult to implement. A policy without rules won't be effective because you can't implement the policy. You can have a non-regulatory policy where you might say promote something rather than avoid or manage or something like that. But again, how effective that is if you haven't got a non-regulatory measure like funding or something like that to support it, then that policy won't be particularly effective, I don't think.
I wouldn't think that it would be particularly productive to be fencing off areas of Indigenous biodiversity for your stock anyway. It would be far better off to fence the whole area and concentrate on the rest of the area where there's pasture grazing and keep the stock from going in there, because quite often they get entangled in vines and they go in there and die. I mean, it's better really management practice to keep them out of the natural biodiversity areas.
Yes, the other thing to note is I think I talked about this on, was it yesterday at the start, that there has been Indigenous vegetation loss. There has been Indigenous vegetation loss across the district over the last 20 years, effectively, and so continuing on how we have been with no management in the plan hasn't been particularly effective.
I think for the purpose of this discussion, we're really talking about within the precinct of the Hokonui Hills, where there hasn't been a net loss. And it concerns me if there's a rule that says total exclusion. We're talking about a large area. This seems to be at odds with council's, I think, obligation or intention to have a plan that actually serves the purpose of the people that are really operating on the land. I'm still looking for a workable solution. I'm not in favour of a heavy-handed exclusion,
So in terms
particularly based on what the eco experts have said.
So in terms of Eco Rule 2, there are a number of things that can occur as a permitted activity. There's a whole list, and including clearance up to 3,750 square metres in Area A and 1,250 square metres in Area C. So it's not a total exclusion, is the point I'm making. There are a number of activities that can occur within those areas as the rule is drafted at the moment.
I think to clarify, Commissioner Boljard, there's no rule at the moment that limits the extent of grazing within that precinct. I wondered if there was confusion around that.
No, I'm aware of that, and I'm not uncomfortable with that. There will be those submitters that maybe suggest there should be. I'm relying, I think, on your assessment that says there's been no net loss. I guess that's a comment rather than a question.
Okay, returning to a question then. page 46 has the definition of SNA and SEVA, which is in your supplementary evidence, also on page 19 of your Appendix A. And there's two issues that arise, and I flagged the issue of Appendix 4 in the plan and Appendix 3 of the Southern Regional Policy Statement, no year given, and we'd have to give a year for it to be valid. Wanting confirmation of the feedback I got yesterday that, in fact, there is some merit in actually bringing those two together so there is a single unambiguous set of criteria.
I think we can do that in a plan. The difficulty we've got is that we have two SNA that are already in existence. Red Tussock at Pukerau and the Croydon Bush Hokanui Hills. They are governed by the NPSIB in terms of Appendix 1, I think, which is effectively the same as Appendix 4, largely, in our district plan. And then you've got SEVAs, which, as I understand it, have been identified using the criteria from the RPS, which are very similar to the NPSIB, but not quite the same.
So when we get to the assessment of land that's covered by the indicative map, which appendix should people be looking at?
So that's the SEVA have been defined using Appendix 3 of the RPS, as I understand it. EVA are just Indigenous vegetation areas that have been identified by remote means by the ecologist. Have I got that right?
Yes, basically. Just a slight refinement. We mapped them using the best available information, which consisted of aerial imagery plus other known information we could find, such as records of at-risk and threatened species from publicly available records, and then used the RPS criteria based on our best available information to go, well, this is likely to not meet a criteria or likely to meet one criteria. So that's the way they were split. The exception to the RPS criteria, however, was that Gore District Council requested that wetland areas were not part of the assessment. Now, in the RPS, wetlands are included in significance assessments. In the NPSIB, they are excluded because the NPSIB only deals with terrestrial habitats. So that's just one anomaly.
Yeah, the reason for excluding wetlands is the regional policy statement says the regional council is responsible for wetlands, not the district council. So the purpose of what that's leading to is that where we have provisions that require an assessment to be done as to whether you're within the mapped areas that are outside of the plan, you should only be doing that assessment in terms of the criteria that are in the RPS. So we can cross out reference to Appendix 4 in those provisions, notwithstanding that in the definition it still applies, but it only applies to the two areas that are already shown.
That's correct. While we're on this definition, you'll see the words council approved by the Diversity Management Plan is still there. That should be struck out now.
Yeah.
So I think there has been no ecological evidence in this hearing to suggest that there is a fundamental difference between Appendix 3 and Appendix 4. Or put it another way, rather than those appendices, that there is no fundamental difference between the NPSIB significance criteria and the RPS significance criteria. In other words, if we relied on the RPS significance criteria, we would not be out of alignment with the NPSIB.
The only relevant evidence tabled would be from the Wildlands memo, which specifically Council requested Wildlands to undertake a comparison of the two significance criteria sets. And so just to read from the summary, overall, the generally broader reach of the NPSIB criteria, and particularly the representatives criteria, will most likely result in more areas of terrestrial indigenous vegetation and habitats of indigenous fauna being classed as significant under the NPS than under the RPS. And so that's probably the key difference, but otherwise I would agree that, you know, your summation is accurate.
Right. Now, there's an inconsistency in the way that reference is made to the two documents. In some cases, it says Appendix 4 or Appendix 3 of the RPS. In some cases, it says Appendix 4 and Appendix 3 of the RPS.
Are you addressing me or?
Either.
Okay.
So do you want to, can you tell us, do you mean across the Section 42A report and
or in the
Appendix
plan,
1?
updated plan provisions? I haven't done a search.
Yeah. So
I
effectively,
picked it up in your 42A report, which
Yeah.
I'm not 100% certain translated into this document.
So that comes back to the fact that Appendix 4 from memory mirrors the NPSIB criteria, which is Appendix 1 of the NPSIB. Appendix, have I got that right?
Actually,
Was it-
doing a word search,
Yeah.
what you just flagged, and appendix doesn't show up in your updated plan provisions.
Right,
I think I probably picked it up from your earlier version.
sure.
So, as you were on that one. Anything else on the first 50 pages from the panel? Venus?
On page 56, we've had a bit of a
The first
discussion.
50 pages, but okay.
Oh, sorry.
Well, it looks like we're starting on the next bit.
Right. I think it is page 56.
Can I jump in just on a point following on from Commissioner Bartlett's question, just to caution again from a legal perspective that having had a discussion about the differences or the similarities in the criteria, that a SEVA is not then in any way equivalent to an SNA, and that is our critical point in terms of the framework that we're applying. And possibly where we've got a little bit of cross-talking with DOC is that DOC may prefer to see the NPSIB applied, but that is not our present framework. That is a future framework. We are currently applying the RPS framework, and we have similarities, but it doesn't mean that we're identifying SNAs.
No, so this is really important in terms of summit. So this is the dialogue I want to have before we move off the first 50 pages. So we still presumably have a need to know, as far as we are able, where significant habitat and significant species reside in the district, and then protect them, and otherwise maintain other Indigenous biodiversity. So that whole dialogue that I had with Doc around protect and maintain, and the objective in the MPS, and then legal counsel saying, well, it depends on the nature of the Indigenous biodiversity and where it sits. So we teased that down, and then we had the 3 tiers that the provisions need to address. The first, well, the tier that we could see that Eco R1 would be addressing would be the things that are not significant and that there are not significant adverse effects in play. So the permitted activity in the 3 tiers needs to ensure that it is if it is going to apply to something significant, and I think this is the concern that Doc have, if Eco R1 is going to apply to something significant, a significant habitat or a significant species, we need to be sure that it is protecting that significant habitat or significant species.
It's not going to lead to significant adverse effects in accordance with 316.
That's not the test. And this is why I'm bringing this up. I think we've got 3 tiers in play, which is where Doc's evidence was important. The 3 tiers, so if we start with the bottom tier, it's not significant, it doesn't pass the significance assessment of the RPS or the MPSIB, and the effects on it are also not significant. Tier 2, the significance assessment criteria is also not met, but there are significant adverse effects occurring. Top tier, it is a significant habitat, it is a significant species, then the test is not significant adverse effects. It's something more akin to what Doc were putting on the table, which was you need to avoid first in order to protect. If you can't avoid, you must remedy. If you can't remedy, you must mitigate. If you can't mitigate, you must offset. If you're going to offset, you have to prove like for like. So that whole effects management hierarchy bit is the bit that kicks in if it's a significant habitat or a significant species. And I feel like at the moment the word that legal counsel for Doc used was conflation, and I do think we might have to be, as we go through the provisions, really clear about which tier we are addressing, and then if it's an identified significant habitat or significant species, are we appropriately applying best practice, which is the effects management hierarchy? And that piece of evidence that said, regardless of whether you are using the effects management hierarchy from the MPSIB because it's an SNA, i.e. we do need to do that for the 2 SNAs that have been identified in the district, regardless, that is long-standing best practice for a significant habitat or a significant species where impacts come into play. So I guess that's my opening salvo, if you like, for every provision that we're looking at. Where are we in using those tiers and the effects management hierarchy? Where is that?
I think regardless of whether you're complying with the the MPSIB, you still have to comply with the RPS, which sets that framework for any areas that are significant in terms of an assessment against Appendix 3 of the RPS, which effectively equates to a SEVA in our indicative mapping.
Thank you. So that's really important. So that was the other thing that was laid down by DOC was we don't know at the moment if, when we're looking at a SEVA, this equates to having addressed the RPS significance criteria. And they were looking for the analysis against that criteria to say, yes, it passes because of this. So I think this is for Mr. Wells, because when I hear you speak, you're expressing confidence that the significance criteria is passed for areas that have been captured as SEVA based on best available information.
That was the aim of our mapping, but with the stipulation that it's based on best available information and based on the clauses in our report stating that therefore it needs to be treated with caution, and that ground truthing will find many exceptions to that, which is the nature of, just to add a side comment, that's why desktop mapping for ecology is highly fraught. Yeah.
Just to be clear, and if we're using the SEVA beyond indicative, i.e., if it's indicative, it's not sitting in the rule framework, it's a signal that we're expecting when you do the ecological assessment through a consenting process, you will find significance. Yeah. The difficulty, I think, arises with the permitted activity rules in relation to a SEVA if with the best available information we've got at the moment, it does appear that a SEVA crosses and passes the significance assessment criteria of the RPS in Appendix 3. Probably for us, it would be helpful to know when you're thinking about your SEVA, which criteria are you leaning on in Appendix 3 of the RPS to reach that conclusion of significance for a SEVA?
So, before you respond, I'm just wondering if it might be useful to provide the panel at some point a copy of the methodology that you've used to identify the SEVA, and potentially, given that some areas have been ground truth through mapping, I don't know if that information's available to the panel in terms of the on-the-ground assessments that have been done.
I'd have to request that.
Just before you proceed, just to highlight, we will break for lunch at 12:30.
So this goes straight to the heart of all of that dialogue with DOC yesterday was and why they were requesting before coming to the hearing that more information be brought forward. And it was that basic methodology plus data plus significance assessment to then see the outcome that was reached. And I do think as a panel, depending on how the SEVA is used and how the rule framework works with it, if we are going to place some reliance on it, that in this area we do expect there are significant habitats and significant species, and therefore a particular regime applies, then we do need those things: the methodology, the data, the significance assessment, and the outcome of that assessment.
Can I just clarify, are you talking specifically about Hokonui Hills, because that seemed to be the focus for DOC in terms of their concern about R2, not so concerned about R1?
Except that in R1 the clearance was still being raised as an issue, and this is why I'm
We're
pointing.
talking about the 50 square metres clearance in R1, are we?
Yes, but I think if we move away from R1 for a moment, and I think you are right that R2 is where the mapping gets pulled into the rule, and therefore why it becomes more critical to have the methodology, the data, the significance assessment, and out the other side. And then what I do want to know though is outside of Eco R2 and we're in Eco R1, I did think there was still a signal coming to us that we need to know and understand that we are protecting what is significant through the rule, i.e. So initially they were pointing to things like the exemptions in the MPSIB. Well, those don't apply to any areas other than Croydon Bush and, Pukeroa. So, but they do apply in those two situations. So we need to know that we're dealing with those in that way and meeting the exemptions that are in the MPSIB for those areas. Yep. But we're not constrained by those exemptions when we look at other areas that might have significant habitat or significant species. But I would think, and this is what I'm just going to note, I would think that it's normal for a rule framework to have a differentiation around what is permitted in areas that are not significant versus what is permitted in areas that are significant, and I don't see that at the moment.
So you're talking about...
Can I just quickly comment as well, and it's an observation about clause 3.16 of the MPSIB, and it's the distinction between use or development and other adverse effects that are not from a new activity. So some of the responses in R1 and R2 are to ongoing activities, not new activities. So in terms of your summary of the three tiers, Commissioner Bartlett, I would submit that you also then need to distinguish an appropriate rule response to ongoing activities as opposed to a new activity.
Agree, and I do think this is really important to that idea of scale, extent, intensity and location, and all of that probably is up front, and so it's where new activity comes in. So if R1 is capturing existing, then absolutely.
I think the difficulty with distinguishing between EVA and SEVA in Rule 1, so having a different framework for EVA and a different, is that we're using indicative mapping, right? And so we had this discussion previously about relying on indicative mapping in the rule and the confidence we've got around that. And so I think that is why whether you're a SEVA or an EVA is irrelevant in terms of getting into the consent pathway. It's Indigenous vegetation clearance that gets you in there. And whether you're a SEVA or an EVA determines the consent category that you need, so discretionary versus non-compliant. Because we're relying on indicative mapping, which is difficult to reference in a rule in a permitted standard. Unlike Appendix 7, where the mapping, we have a lot more confidence in that mapping. So you don't need to test that through a consent process, you need to test whether you're a SEVA or an EVA in a consent through a consent process.
Yes.
And I would urge the panel to consider the certainty obtained through this process in respect of Hokonui Hills for an existing activity. So the certainty of the protections that are obtained over those mapped areas is a matter for your consideration in terms of management through the rules of an existing activity.
Yes, and then the new activity component comes in, and those ideas around effects management, hierarchy and protection. Yeah. Okay.
Can I just follow up on something I guess is related to the identification and what came from Doc as well? How practical is it to do a lizard assessment of the Hokonui Hills?
I knew that one would come up. It's a difficult.
What sort of cost estimate are you looking at?
I guess we probably need to step back and go, what's involved in a lizard survey? Lizard surveys are probably, of all the ecological undertakings you could do, are the most labour intensive survey type. For an area the size of Hokonui Hills, to undertake a lizard survey to give any meaningful understanding beyond what we currently have, you would really be putting out, as Ms. Zammit-Ross briefly alluded to yesterday, you'd be putting out what they call ACOs, artificial cover objects, but you'd also probably be putting out pitfall traps, and you'd probably also be putting out G-minnow traps. And if you wanted to try and find out whether there were species such as the green skink or other species, then you would be requiring much finer scale measures. All of that to say, I wouldn't dare put a figure on it, because these things take an experienced herpetologist a good day to cost out and to formulate the plan. But I know for a fact, based on similar areas that Wildlands have been asked to price for lizard survey in the Southland region, of a much smaller scale than the Hokonui Hills, you would, at a minimum, be, please don't quote me on these costs, you know, this is me going what I've seen and how big the Hokonui Hills complex, a minimum for the survey I would expect would be $75,000 to $100,000. But the implementation of any lizard management plan followed by Wildlife Act Authority would then generally run into more than that. So that's just an indicative. Obviously, if we're talking about a small area of permitted clearance, that would be a smaller survey, but the costs would still be in the, to do anything meaningful followed by management measures, you'd still be in the tens of thousands based on my experience of lizard survey and implementing management plans in the Lower South Island. Again, please don't make those costs anything more than
Okay,
indicative.
so time-wise, is there particular times of the year as well that you would need to do it?
Yes, so you have to do it within the active lizard season, which is in the southern parts of the South Island. You'd really be wanting to do it between October and early April is generally the accepted lizard season. Now that does vary depending on the species that you might be trying particularly to target.
Does the weather, if it's warm or not, and whether they're out of their habitat, does that?
Yeah, so basically outside of that general period that I designated, as generally the lizards are inactive and it's not worth surveying. Within that period, you still need to be undertaking your surveys on days when it's of an appropriate temperature. So there are days, for example, when it's raining, you can't undertake your survey. So generally you put out your traps or your other things, you leave them for a long period of time for the lizards to get used to them being there, and that's followed up by at least 5 to 10 consecutive days of revisiting everything that you've set up. So it's quite a detailed process, but very well understood about how you go about it.
So I then turn to Natalie in terms of the cost benefit of doing such a study.
That's a good question.
Yes, and I'd say that that wouldn't stack up relative to the rules that are permitting clearance in the Hokonui Hills and the benefits we get out of the marginal change in biodiversity.
Would it be most relevant to new activities, i.e. not relevant to existing activities, most relevant to new activities?
Yes, definitely. I had a good conversation with our senior herpetologist about this issue, particularly in the Hokonui Hills prior to this hearing, and she made the comment to me that for new activities, but particularly for larger scale activities, then that's when you really get into really good economies of scale in terms of genuine positive benefits for lizards. Her comment to me was often in the smaller things involving existing uses, there can be very large expenses, often for quite marginal benefits. So that was her initial comment on that. I'll just add one point which she also conveyed to me, which I think is in line with the Department of Conservation's, some of their concerns potentially. For particularly threatened species, they can sometimes hang out in unexpected little clusters for no good reason. And so that's the only other comment that I'd add in there, you know, and when we look at it, we go, oh, that's interesting. And so that's probably the only caveat that I would add to that, is that sometimes, and those things can sometimes be surprising to herpetologists.
Can I just also add, are we talking about new activities in particular areas that Department of Conservation are concerned about, i.e. the 127 hectares, versus the whole SEVA, SEVA or area A or B?
Yeah, I think this is an important question you ask because it's a question I also have. So what I think we've got from the doc evidence and nobody's suggesting that the 127 hectare area is not significant or that it would not pass the significant assessment criteria. The question that you're asking is really, do the other, which is why I was asking these questions earlier, do these other SEVA areas on the Hokonui Hills also contain significant habitat and significant species? If the answer is yes, then the law would treat the 127 hectares and the other parts of the SEVA the same, which is not to say that they are the same in terms of they've got different things going on, each one, no doubt, but the point of it is that the effects management hierarchy approach would be appropriate if the remainder of the SEVA area also passes the significance assessment criteria. And that's the reason for sort of going down that road and querying, you know, what's our basis for landing on that use of significance? Yeah. Because I do think we have very clear indications that a protective regime for the 127 hectares that incorporates the effects management hierarchy is the acceptable path. But again, why would we say that? We would only be saying that because it's past the test of significance criteria. And so the same logic should apply where significance criteria has identified a place or a species.
I think it's a bit finer grained than that. So if you think about what we're doing across the district, we've identified SEVAs using remote mapping, and we think they're there, but we can't be certain. Then we've had a broad scale analysis done of Hokonui Hills, which is so that information's a bit better, probably a lot better than the remote mapping that we've had done. And we've now had evidence from DOC that says this 127 hectares, because we've been working in there and restoring it, etc., is an even a known higher value than the other SEVA in the Hokonui Hills. So, you know, because of that broad scale approach we're taking across the district, you could argue that we've done more work here, therefore we're more certain about it, therefore we can have a stricter rule framework than the other SEVA in the Hokonui Hills, and that's stricter than the SEVA everywhere else.
So there's two things going on. There's level of certainty, important, but there's also, if you've got reason to call it significant because it's past the significant assessment criteria. That's why I'm just going to keep hitting on that, because if that's what a SEVA is, where more work has been done compared to indicative SEVA that's sitting outside the rule framework and may or may not and needs further work. But if we've got a cohort that includes the 127 but the rest of the 650 on the Hokonui Hills that's bundled into SEVA, it's probably that bit in there that we need to understand, has the rest of that crossed the threshold for significance, and if it has, then we need to respond to that.
We need to manage new activities to a scale that is more than negligible. I think the word was used the other day. So the 50 square metres clearance.
Well, it's the Eco R2 in the Hokonui Hills.
Yeah.
Yeah.
Can I jump in with a comment?
It's only that.
Yeah,
it's only K.
The thing about
For SEVA.
a significance assessment is it identifies ecological values which make that particular area significant. So when it comes to managing a particular area which has been identified as significant, the key is what are the specific ecological values that give that specific area ecological significance. So it's not this brush rule, oh, that's significant, therefore it needs to be protected. It's actually what values are they that give it that regime, so therefore how do we ensure that those values are protected? And protected means,
Yes.
never means can do nothing, it means what is inappropriate must be avoided, but other activities, as long as they protect those core values which give significance. So that's probably
the effects management hierarchy. So you're right, and everything that you just said, I followed it perfectly well.
Yep.
That it is the significance criteria that determines. Yep. So if the part of the SEVA on the Hokonui Hills outside the 127 hectare area does meet the significance criteria, then it's top tier for new activities. And then the new activity, whatever it is, needs to follow the effects management hierarchy. First avoid, remedy, mitigate, then offset.
Right, so I take it as a statement, and is that an appropriate time to break for lunch?
He was preparing to respond, thank you.
We just do one. I think this is good to finish this. Is that all right?
Yeah.
It's not, and I totally agree. I guess the point I was trying to make is that Mr. Davis's survey and my survey of Wantwood, that is the process we followed. Now, the key in an assessment is identifying ecological values and then ensuring that they are managed so as to avoid significant adverse effects. Now that applies whether or not you unless it's an SNA under the NPS, and then it shifts into a whole different rules framework. But otherwise we go into the general vegetation. And so in that case, I'll just quickly finish. So what I noticed in paragraph 45 of my evidence was that regarding these significance assessments, I remain of the opinion that SEVAs in areas C and D meet the SNA criteria in the MPSOB and RPS. while I have not undertaken a formal assessment for the many discrete vegetation patches that comprise, okay, we won't worry about that part. Paragraph 46, regardless of how these areas are categorised with respect to significance, I remain satisfied the proposed management regime for the Hokinuihui Hills will ensure the overall protection of the ecological values that give importance to areas A to D. So that was I totally agree with Doc that there wasn't an itemised significance assessment, but as Mr. Davis also noted, that process was followed, but for various reasons that was not put into a significance framework, although the exact same information was gathered and the same, if you like, effects management thinking was applied.
The one thing I would challenge you on and turn to Mr. Hill on is that once you've identified significance, so you followed that, it wasn't a formal assessment, but you utilised that criteria to determine that these were the places where significant habitat and significant species were. Now, at the point that that happens, then I look across to Mr. Hill and I go, we've hit the top tier of the three. The test is not significant adverse effects on this. The obligation, therefore, is to protect and utilise the effects management hierarchy. And I think that is the difference that I heard in the response just then, was thinking maybe about significant adverse effects, but actually once we've got the significant thing identified, a different regime comes in terms of protection, and that is the effects management hierarchy.
Yeah, I guess it comes down to what you mean by protect. So are there some things that can occur in that area that still achieve the overall goal of protection?
That's where I think this is an important point to get to. That's where the exchange with Doc around what protect means was really important, and what maintain means was really important. So what they've said to us is, when you've identified something significant, so it hits section 6C, then the appropriate thing to do in terms of best practice is to, at that point, employ the effects management hierarchy, which is different to then determining whether it's significant adverse effects that are in play. There's something else happening with the effects management hierarchy.
My experience, though, is that there are, if you look at plans around the country, they don't say you can't do anything in a SNA or a SEVA equivalent. There are activities that you can do, okay? And they're still trying, all those other plans are achieving section 6C. So there are some things that you can do within a identified SNA or SEVA as a permitted activity. So for example, in my experience in Waitakere City, which has 100% coverage in the Waitakere ranges of significant natural areas, you could still clear vegetation up to 500 square metres to establish a house, because you need to balance that protection with reasonable use when you're developing a district plan. So I don't think outright protection means you can't do anything. Now, we haven't adopted the 500 square metre clearance approach here, because we haven't got 100% coverage of SNAs. That, we've heard this morning that most of these properties are below 10% coverage, which means from a reasonable use perspective, you've got a whole lot of other land that you can develop on without impacting these areas.
So I want to stop there and adjourn until 1:30. Thank you.